Good morning. Happy Saturday. This is probably going to be a two-part video. I don't know exactly yet. We'll see how fast we can get through it. But right here, this is our boy Fred Gutierrez. Yes, it is our boy Fred Gutierrez. You can trust me on it. You could wait to see the pleadings that he filed. It is definitely our boy Fred Gutierrez. Everything matches. Anyway, so our boy Fred Gutierrez in 2012 got himself a little ticket for no plates and no license. And he had a bench trial where he was convicted on both counts. Oh no, right? So what do? Well, obviously, you sue the judge. Now, who would have thunk that suing the judge would be the way to go? Timothy Atkins. Who's Timothy Atkins? Timothy Atkins was the judge. Judge Timothy Atkins, right here. So he's suing the judge. He's suing the judge for deprivation of rights under 42 U.S.C. 1983. This is an action brought by plaintiff against state officials in their respective roles in their corporation of political subdivision and in their individual capacities who, while acting under the color of law, did willfully and with intention deter, suppress, or otherwise breach some rights of plaintiff guaranteed and protected by the federal Constitution, particularly the First, Sixth, and 14th Amendments. The First Amendment is freedom of speech. Sixth Amendment is right to counsel. 14th Amendment is what makes some of the other amendments applicable to the states. This action involves actions of defendant Atkins in a proceeding absent subject matter jurisdiction, a bad faith prosecution argued by defendant Graham, who is the prosecutor, and collusion conspiracy of the defendants to convict plaintiff and avoid proceeding. Yeah, they colluded. The prosecutor and the judge colluded. We gotcha. All right, so jurisdiction, awesome. Parties, awesome. General factual allegations. In 2012, Gutierrez was in operation of a van registered in Arizona to another party. Okay, maybe not. Plaintiff was departing from Laughlin, Nevada, some 100 miles from plaintiff's home while on a casino boulevard, where plaintiff was signaled to pull over by a law enforcement officer, later identified as Matthew Serbin, and detained for approximately 45 minutes. He filed an affidavit with it. Plaintiff informed Serbin that he wasn't the owner of the van. The van wasn't registered to plaintiff, and the plate and registration were valid through September of 2012. So the cop issued him a citation, and it's unlawful to drive a motor vehicle without being the holder of a valid driver's license, and he had to get a driver's license. So plaintiff made a special appearance because the sovereign citizens think you can make a special appearance in a criminal case. Okay. No. So anyway, he made a special appearance before Atkins, and he was the only party present at the proceeding. At this time, Atkins reported plaintiff that this proceeding was an arraignment and then asked plaintiff to enter a plea to the charges. Plaintiff said he would love to enter a plea if it could be demonstrated how the jurisdiction of the court had been initiated in the absence of any lawfully made complaint or summons supported by a charging instrument containing or supported by any sworn statement. This is a deviation from the Mark Stevens, who is a known sovereign citizen. It's basically just a deviation from the Mark Stevens playbook. So no plea was entered by plaintiff, and the matter was continued until or about October 11th of 2012. I believe October, a criminal hearing was held. Trial was continued. Bench trial was held on November 29th. So let's see what happened on October. Information: he refused summons by mail. He was sent notice of court appearance. He refused summons by mail. Hearing was vacated 8th. So on the 9th, he was sent for court appearance. And the hearing was held in September 25th. October 11th, there was a hearing held. It was apparently recorded. There was a trial set. That means a response of not guilty. A plea of not guilty was entered. There was the information. It was set for court appearance. It was set for trial, non-jury trial. And the trial was continued at prosecution request. Trial was held on the 8th. Oh, no, it was continued by prosecution request. 8th was continued. So the 11th hearing was held. I'm sorry, the 29th, the hearing was held November 29th. And he was found guilty as charged. Okay. All right, so we have the basic background in place. So, on around October 11th, Deputy Prosecuting Attorney appeared in the proceeding. Craig, as representative for State of Nevada. Plaintiff asked that opposing counsel prove jurisdiction on the record as a matter of law to factually demonstrate the prosecution had been properly initiated and that Gutierrez could formally be charged. Jurisdiction was challenged and not proven by prosecution. Oh, it wasn't proven. Then how did the hearing go forward, buddy? In response to this challenge, Atkins declared that jurisdictional challenges would not be allowed as I am the only judge and this is the only court. Now, who do you know of that has alleged similar statements being made by judges in court? I shudder to think that a nascent attorney who is still in his fledgling stage, wondering if he's passed the bar or not, I wouldn't dare to assume that a nascent attorney would make some statements like that. Now, it was recorded. It does say several times that each time it was recorded. Bench trial was held, it was recorded. So there's a record made. So you would think that you would get a little bit more of a quote than just the one thing that Gutierrez heard that he thought, oh, this will make the judge sound bad. The judge might have said all of the explanations earlier, and then the 32nd time that Gutierrez demanded to know the judge's rationale, the judge might have then said, the judge might have said something along the lines of, I'm the only judge and this is the only court. As far as a jurisdictional challenge is concerned, I'm the only judge that can hear this, and this is the only court that it can be heard in. So anyway, Atkins asked plaintiff if he would like to make a plea at the proceeding so a trial could be scheduled. Plaintiff restated his request. Prosecution proved jurisdiction. Yeah. Mark Stevens all over again. And Atkins scheduled the matter for trial on or about November 8th without a plea from plaintiff. No, the judge entered a plea of not guilty for plaintiff. Because plaintiff was informed by the clerk, there's no mechanism for allowing the filing of documents in the lawful and justice court. Plaintiff served the prosecution in person, and the bailiff served Atkins plaintiff's motion to quash the citation in all proceedings. Plaintiff appeared for trial on November 8th with numerous witnesses. He was informed by the state that the witness was unable to appear at this trial. Atkins said because the witness Serban was unable to appear because the witness had a doctor's appointment which conflicted with the trial, Atkins would reschedule the trial for November 29th. Plaintiff said the plaintiff was ready for trial and the matter should be dismissed with prejudice as there's no witness present for the state. Well, it doesn't work that way. Atkins denied plaintiff's oral motion. Plaintiff requested a few moments to determine if this new date would not conflict with plaintiff's existing travel schedule, which Atkins denied. Atkins said 3 weeks is plenty of time for anyone to make arrangements to appear. The court will oftentimes, the court has some power in this matter to make some accommodations for defendants in criminal trials to, like if the defendant said, I have some, like a surgery set for this date, the court would probably be somewhat sympathetic to that. But you got to remember that you're the criminal defendant in this matter, and it's going to be inconvenient for you, we know, and you'd like to kick it out as far down the road as you possibly can to avoid having to deal with the consequences of whatever you've been charged with. We get it, we understand, but at the same time, the hearing has to be heard at some point in time. So There you go. So at the conclusion of the proceeding, Atkins said he was denying plaintiff's motion to quash. Plaintiff then asked Atkins, by what fact and law is the motion being denied? So he's asking, I guess, for a statement of decision, to which Atkins replied after a pause, I didn't like anything you had to say in there. Well, maybe he said that, maybe he didn't, but he apparently disagreed with the basis of the motion. So plaintiff returned to the Laughlin Justice Court for a fourth time, to make an appearance before Atkins. Prior to the commencement of the proceeding, Deputy Prosecutor Graham, Atkins, and Serbin all simultaneously entered in the courtroom from a side door inside the courtroom. At the commencement of the trial, Graham placed a copy of the plaintiff's motion to quash on his table and in front of Graham. Plaintiff again addressed the jurisdiction in the court not being properly initiated in plaintiff's opening statement. Despite the absence of the necessary and essential facts on the record to support the initiation of this prosecution, Atkins stated, I have already warned you several times you will not be allowed to say anything about jurisdiction because I am the only judge and this is the only court, so I have jurisdiction. The trial will continue. Yeah, I mean, you've made a motion. The motion's been denied. You could appeal the motion, but just keep bringing it up over and over again doesn't serve you any purpose. Plaintiff objected to proceeding in the absence of the initiation of the court's jurisdiction, and Atkins stated that plaintiff's objection was sustained. Although sustained is not a recognized word in the English language, it is unclear what Atkins meant sustained, as Atkins made other decisions to sustain the party's actions throughout the proceeding. I don't think plaintiff's objection was sustained. I think plaintiff's objection was overruled, and I don't know. Atkins stated the plaintiff's objection was probably, he said sustained, although there might be a typo in the record. Anyway, plaintiff was interrupted and verbally interfered with throughout the proceeding by Serbin, Atkins, and Graham from reading the charges outlined by the statutes of Nevada onto the record, questioning Serbin in order to determine his competency, presenting and addressing case law on the record, and related influential case law, including Nevada revised statute. Trial is not where you introduce case law. You don't introduce case law at trial. Trial is to determine the facts. The judge determines the law and will instruct the jury. Usually the plaintiff and the defendant will offer competing sets of jury instructions, which are instructions to the jury on the law. The judge will then select between the offered jury instructions, or substitute his own, or come to a compromise between them of some sort. And then he will instruct the jury based on those agreed or ordered jury instructions. And that's the law. You don't start quoting case law. People like to think that trial is some sort of a debate. It's not. It's to establish facts. So anyway, he's trying to quote case law here. At the conclusion of the trial, Serbin stated he had no factual proof or evidence supporting the charge under that particular statute, and that he could not demonstrate by any fact plaintiff knowingly acted. Serbin is the officer. I don't know. That'd be a weird question to ask the officer. The officer doesn't have to prove plaintiff knowingly acted. The other facts can establish that, like the fact that plaintiff was driving a vehicle and the plaintiff stated that he didn't have plates. The plaintiff stated that it was owned by somebody in Arizona or whatever. So you would have an understanding of the plate situation, etc. Yada yada. So Atkins found plaintiff guilty of the charge and asked if plaintiff had a driver's license in plaintiff's possession in the court, to which plaintiff stated he had no driver's license on his person. So Atkins found plaintiff guilty, yada yada. It was a policy and or custom of the city and county to inadequately supervise. Well, that should be its own little statement because he's apparently trying to insert a Manel claim in there. Defendant Graham believed his actions should not be investigated or sanctioned by supervisory officers, and their misconduct would be tolerated. Indeed, to date, their actions have been ratified by the superiors. Yeah, generally speaking, the prosecutor's office, the DA's office, generally approves of their prosecutors prosecuting things. It's kind of weird how that works. But anyway, sovereign citizens are going to sovereign citizen. So violation of his right not to be subject to a bad faith prosecution. I don't necessarily know what that means. I don't know what that means. I don't know what that means. I really don't know what that means. A bad faith prosecution. If the prosecutor has probable cause and he believes that he can prove it beyond a reasonable doubt, then he should proceed with the prosecution. And since he achieved a guilty verdict, then it's hard to imagine that he didn't have probable cause and that he couldn't prove it beyond a reasonable doubt. Now, the motivation for bringing the prosecution isn't really something that, like, if the prosecutor doesn't like you and he brings a charge against you that is supported by probable cause, and that he then proves beyond a reasonable doubt in court, the fact that he doesn't like you is irrelevant. Why he brought it is irrelevant. The question that the court is going to look at, and the Court of Appeals will look at, is whether or not he had probable cause and whether or not he reasonably believed, or whether or not he could prove beyond a reasonable doubt, whether or not, he could prove it beyond a reasonable doubt. Technically, all he needs is probable cause, but he should drop it if he doesn't think he could prove it beyond a reasonable doubt, because that just wastes court time and resources. Count 2 is due process. He was served with the citation, so I don't know why. So he's praying for punitive damages and general damages against Atkins. All right, so there you go. All right, let's see how much time I have left on this. I got 5 minutes. Well, I'm going to make this part 1. Part 2, we're going to go into the motion to dismiss, the opposition to the motion to dismiss, and the order. And I guess I'll make part 3 the motion to vacate, the opposition to the motion to vacate, and the order. So we'll leave it there. Thanks for watching. Have a great day.